Okay, good morning, everybody, and thank you very much for joining us at this morning's webinar when we're going to be talking about local authority duties for asylum seekers in Scotland and just understanding some of that legal responsibilities and support that's to be provided by local authorities in Scotland. Myself, my name is Fiona MacLeod. I am a partner and a solicitor advocate, and I sit within our strategic risk, government and compliance team within Brodie's with a particular expertise around public law. I am an accredited specialist in housing and residential tenancy law and work quite closely with a number of local authorities in relation to their housing, children's services and social care services. I'm going to be talking to you today on the accommodation of the provision of support, and legal duties to asylum seekers in Scotland. We're going to chat a little bit around the provision of accommodation, and then we're going to move on to the provision of health and social care services. We're going to talk about unaccompanied asylum-seeking children, and I know that that's something that comes up quite regularly for local authorities. And then in the context of unaccompanied asylum-seeking children, we'll have a little look at age assessments. So just to start off, I think we'll just get started now. A couple of minutes in, there may be some people that will still be joining, but we'll get started because there's quite a lot to get through in relation to this topic. So it's going to be a bit of a canter, but please bear with us while we go through that. So just firstly, having a look at the role of local authorities. So what's the role of local authorities when it comes to asylum seekers in Scotland? Well, the UK signed the United Nations Refugee Convention in 1951, and what that means is that we have agreed to offer sanctuary to people who are fleeing persecution in other countries. People who are fleeing persecution can come from any country, including countries that may appear safe to some people, but are not safe for everyone, and these people can claim asylum. An asylum seeker is an individual who has arrived in the country from abroad and made a claim for refugee status. Their claim must be registered with the Home Office. The claimant will continue to be classed as an asylum seeker until a final decision is made as to whether they should be granted refugee status or leave to remain in the UK. It should be noted that formally asylum seeker is not immigration status, and it simply describes someone who has applied for the immigration status of a refugee. An asylum seeker granted refugee status or any other form of leave to remain has the same entitlements to public housing and welfare benefits as a British citizen. When temporary leave runs out, this entitlement continues as long as an application for extension of leave is outstanding. Quite commonly, local authorities will required to support and provide advice to those who may have no recourse to public funds. People who have no recourse to public funds will not be able to access most social security benefits, homelessness services, and local authority allocation of social housing. But in some cases, which we will come on to talk about later, they may be able to receive accommodation and financial support from social work services. So, for example, a local authority may have a duty under social work legislation to support NRPF families with children or vulnerable adults, even where a person's immigration status does not prevent them from accessing those social security benefits. The responsibility for providing accommodation and financial support to asylum-seeking families or individuals will very much depend on the status of their claim and whether they would be eligible for Home Office asylum support under Section 4, Section 95 or Section 98 of the Immigration and Asylum Act 1999. And just for ease and to stop me getting tongue-tied, I'm going to refer to that as the 1999 Act. The Home Office is responsible for providing accommodation and financial support to asylum-seeking families, including where the parent's claim is unsuccessful and their appeal rights exhausted. Local authorities may be responsible for providing accommodation and financial support to asylum-seeking adults with care needs who require residential accommodation, and to some appeal rights exhausted asylum seekers who are assessed as having community care needs. And care packages and other assistance may need to be provided to adults with care needs who are accommodated by the Home Office. Although the Home Office should, in the first instance, provide emergency support, where there are some delays in accessing this and a family or vulnerable adult has no alternative funds or housing available, then it may fall to the local authority to provide accommodation and financial support to people seeking asylum. And so a GIRFIC or a community care assessment would need to be carried out to determine the eligibility under Section 22 of the Children's Scotland Act 1995 and Sections 12 or 13A of the Social Work Scotland Act 1968. There are no restrictions on providing social care services to a child within an asylum seeking family. So, for example, to meet any needs arising from a disability. And local authority officers working in frontline services need to be able to understand how a person's immigration status affects their entitlement to benefits and other services in order to ensure that people receive all the services that they're entitled to, establish the correct referral routes, and take any necessary steps to alleviate destitution. So that is the role of local authorities. Just turning to the provision of accommodation. Under the 1999 Act, the Secretary of State for the Home Department, the Home Secretary, may provide temporary asylum support, including accommodation, until the Home Secretary is able to determine whether asylum support may be provided in terms of the 1999 Act. The Home Secretary must provide support to asylum seekers and their dependents who appear to be destitute or likely to become destitute. A person is destitute if they don't have adequate accommodation or any means of obtaining it, whether or not their essential living needs are met. In deciding whether accommodation is adequate, the Home Office should consider whether it would be reasonable to expect the applicant to continue to occupy it. In deciding this, the Home Office should take into account a number of factors, and those factors include: is the accommodation affordable? Does the accommodation allow the applicant's dependents to stay with them in that accommodation? Will remaining in the accommodation put them at risk of domestic violence? Can the person secure entry to the accommodation? If the accommodation is in a movable structure, do they have somewhere to place it? And can they reside in it? Has the accommodation been supplied on an emergency basis? And what circumstances prevailing in the district? What are the circumstances prevailing in the district where the accommodation is located? There are certain factors that the Home Office may not take into account. So they cannot take into account whether the person has a legal right to occupy the accommodation, whether the accommodation is shared, whether the accommodation is temporary unless it is emergency accommodation, pending an asylum support decision, and the location of the accommodation. An asylum seeker may also be classified as destitute if they have adequate accommodation or the means of obtaining it, but can't meet their other essential needs. So in deciding whether an applicant has sufficient resources to meet their essential living needs, the Home Office will consider the following factors. They're going to consider the income of the main applicant, or any income that their dependents may have or are likely to have, any support that they have or their dependents may reasonably be expected to receive, and assets such as cash, savings, investment, land, vehicles, and goods held for the purposes of a trade or other businesses. In accordance with Home Office policy, individuals who are in private accommodation and who have been granted subsistence and accommodation under the 1999 Act are not moved to asylum accommodation unless they make further contact with migrant help to request urgent accommodation. And this is a result of the pressures that are currently on the asylum accommodation estate and the prioritisation of those in initial and contingency accommodation for dispersal. Individuals will need to notify migrant help and should be signposted to migrant help in terms of their rights under Section 95 of the 1999 Act, and that's the grant of support. The accommodation provided will likely be initial accommodation provided in terms of the 1999 Act, and that includes things like hotels, hostel-style properties in a range of areas across the UK. and will generally be allocated according to the overriding principle that it's offered on a no choice basis. Initially, in Scotland, Glasgow was the only asylum dispersal area, with the result that the local authority and third sector services that provide specialist support to asylum seekers were largely located in Glasgow and across the Central Belt, and in other large cities such as Edinburgh. Mears is currently contracted by the Home Office to manage asylum accommodation in Scotland. And until the COVID-19 pandemic, this consisted mainly of shared flats and houses subleased by Mears from private landlords in the Greater Glasgow area. But since the pandemic, Mears has increasingly made use of private hotel accommodation in a number of local authorities in Scotland, and that includes Aberdeen, Falkirk, Perth, and Lanarkshire. And ultimately, in considering whether local authority duties are engaged, the question that local authorities should ask themselves is whether destitution is the only element that creates a need for care and attention. If it is, then the asylum seeker will not be eligible for assistance from their local authority. So just moving on to the next slide. If the answer to the last question that I just posed is that destitution is not the only need for care and attention, then local authority duties will be engaged. And in terms of Section 118 of the 1999 Act, a local authority must secure that so far as practicable, a tenancy or license to occupy housing accommodation provided under the accommodation provisions is not granted to a person subject to immigration control unless permitted under an order made by the Home Secretary. So that is to say that local authorities should not be providing accommodation if the appropriate provisions of the 1999 Act in terms of the Home Secretary's duties are engaged unless there is an order made by the Home Office to the effect that they are to do so to support and alleviate the pressures that are on the asylum accommodation system. The exceptions to that general rule, because there's always an exception, is that the provision of interim accommodation should be provided while a community care assessment is being completed, or in certain circumstances where the local authority considers that the likelihood of an assessment under the 1968 Act will result in the provision of residential care accommodation. In practice, this means that local authorities should not provide accommodation directly to asylum seekers so far as is practicable. But this does not preclude asylum seekers from taking on private leases or taking on tenancies from registered social landlords. So what are the housing options when an asylum seeker is granted leave to remain in the UK? When an asylum seeker is granted leave to remain in the UK, the accommodation provided for them by the Home Office will be withdrawn. And at that time, they will need to seek alternative accommodation. There are a number of options which are set out in this slide, and just going through them very briefly. The immediate options of asylum seekers granted leave to remain will often depend on who their housing provider has been. In some cases, so for example, if they're in private accommodation, they may be able to stay in the current accommodation after asylum support has been withdrawn. There may be an application to the local authorities' homeless services, and all former asylum seekers who were supported by the UK Border Agency will lose their automatic right to occupy their accommodation when they're granted leave to remain in the UK. And at this point, that may be when they will approach their local authority to make a homeless application. The local authority will then have a duty to provide them with temporary accommodation until it's able to decide whether it has a duty to provide permanent accommodation in terms of the Housing Scotland Act 1987. When an asylum seeker is granted leave to remain, asylum seekers living in local authority accommodation will also be given the opportunity to sign a temporary or permanent occupancy agreement relating either to their current home or another local authority property. There are also temporary tenancies. So a temporary occupancy agreement will allow the individual to remain in their current accommodation on a short-term basis. And accepting an offer of temporary accommodation allows the individual time to decide whether or not they want to stay within the local authority area. Signing such an agreement does not prevent them from subsequently being classed as unintentionally homeless if they decide to make a homeless application in another local authority area. And by offering this type of accommodation, the local authority may be discharging its duty to provide temporary accommodation to the individual as a homeless person until permanent accommodation can be made available. If it is ultimately decided, in terms of the provisions of the 1987 Act, that the individual is eligible to receive permanent accommodation. Failure to sign a temporary tenancy agreement in these circumstances for an existing or alternative property may result in eviction for the individual, and then the individual may have to approach the local authority with regards to making a new application in terms of the homeless services. So it is something just to bear in mind if you're providing any support. If the asylum seeker is living in an asylum support accommodation that is not provided by the local authority, or if the accommodation is unable to be used as temporary homeless accommodation, then they'll probably be served with a notice to quit as soon as asylum support ends. The asylum seeker will then present themselves as homeless to the local authority. And again, in such circumstances, the local authority will thereafter have a duty to provide the individual with temporary accommodation until it's determined whether the individual would be eligible for permanent accommodation. If the asylum seeker decides not to remain in the local authority area, then they should support the council's refugee support team with regards to making an application for homeless accommodation in another local authority area. And finally, just to touch on alternative housing options, those individuals with leave to remain are entitled to apply and be housed by registered social landlords and also private individuals. Although just a word of caution in terms of the private rented sector, although individuals with leave to remain are entitled to secure their own accommodation in the private rented sector, this is generally only going to be possible for those who have money available for a deposit and advance rent payment. So it is perhaps more likely than not that the support will be sought from the local authority housing, or alternatively from a registered social landlord in a form of social housing in the first instance. So that's the provisions around accommodation and housing options and duties on local authorities. So just touching now and turning to some health and social care aspects of the support that ought to be provided. And in particular, in the first instance, looking at providing support for adults. When an asylum seeker is referred to the local authority and presents with an appearance of need, they must be assessed in the usual way with a view to determining whether they need to be provided with any social care services in accordance with the Social Work Scotland Act of 1968. And the Home Office has published updated guidance to clarify its role in helping asylum seekers with care needs access support from the local authority, as well as confirming which organisations will be responsible for providing accommodation. The guidance applies to Scotland, but the legislation that it refers to is English legislation. It's referring to the Care Act 2014. Those that are aware of the Care Act 2014 will know that it has a very different eligibility criteria and framework for providing care to that which applies in Scotland. So local authorities should refer to this guidance, be aware of the guidance that's being provided by the Home Office in relation to provision of care and support. However, we'll need to make sure that all decisions that are made in Scotland properly comply with the local authority duties under the Social Work Scotland Act 1968. If the adult has not yet accessed support from the Home Office, the local authority would be required to undertake a community care assessment to establish what assistance they require and whether residential accommodation is necessary to meet the person's needs. Whilst assessments are being carried out, the local authority may need to provide interim accommodation if the adult has no alternative housing available to them, and we touched on that a moment ago. If residential accommodation is required, the local authority will need to provide and fund this. If the person requires care which can be provided within the community, then the Home Office guidance suggests that suitable asylum support accommodation will be sourced, and thereafter any care services and support services can be provided by the local authority. An asylum seeker or an appeal rights exhausted asylum seeker who is presented with an appearance of need should only be referred to the Home Office for support when the community care assessment has been completed and the local authority has identified whether they're eligible for assistance, and if so, what kind of support will be required. If interim support, including housing, has been provided pending the outcome of the assessment, then it would be good practice for the local authority to assist the person to apply for asylum support if residential care is not required. If the adult has been referred to the local authority when they're already living in Home Office accommodation, then a community care assessment should be carried out as usual. The local authority should disregard the availability of Home Office accommodation and identify whether residential accommodation is in fact required. If non-residential care is required, then the local authority must consider whether the Home Office accommodation suitably allows for the adult's care needs to be met, and if not, would need to request the Home Office sources or appropriate accommodation in line with the guidance that has been provided by the government. The provision of support in terms of the 1968 Act is not limited by Schedule 3 of the National Immigration and Asylum Act 2002 for adults with pending an asylum claim. This particular schedule is in relation to adults pending asylum claims which have not been finally determined, or for adults who have claimed asylum at a port of entry, even if they have been refused and are appeal rights exhausted. So essentially what that is saying is that the provision of a support in terms of the 1968 Act is not limited in those circumstances. However, that Schedule 3 exclusion will apply to appeal rights exhausted asylum seekers where the adult claimed asylum after they entered the UK rather than at the port of entry, or if they have refused to comply with removal directions. The Schedule 3 exclusion restricts a local authority's ability to provide accommodation and financial support to a person who is in breach of immigration rules and to some other groups where the person can return to their country of origin to avoid destitution. In such cases, care and support, including accommodation, may only be provided where it is necessary to prevent a breach of the person's human rights. So, for example, if there is a legal or practical barrier preventing them from returning to their country of origin. So, the local authority will need to undertake a human rights assessment to establish this, as well as a community care assessment. So, it is just to bear in mind that the local authority will also need to ensure that any decisions that are being made are human rights compliant decisions. So that's providing support for adults. Just moving on to providing support for families and children, which is a slightly different legislative framework. The responsibility for providing accommodation and financial support to asylum-seeking families depends on the status of the parent's asylum claim and whether they would be eligible for Home Office asylum support under the 1999 Act. And the details of that are set out on the next slide, which I will touch on very, very briefly. The slides will be sent to you after today's webinar, so you can look at the next slide in a wee bit more detail when we get on to that. The local authority would need to establish the status of the parent's asylum claim in order to determine which type of support is available to them. It's important to obtain confirmation that the parent has claimed asylum, the current status of the claim, and if it has been refused, what's the date of that initial refusal, and any appeal decisions and the date the parent became appeal rights exhausted if they have received a final determination in relation to their claim for asylum. Even when a family can be referred to the Home Office for support, either because they're eligible under Section 95 of the 1999 Act for support or Section 4 support, it may fall to the local authority to provide accommodation and financial support under Section 22 of the Children's Scotland Act 1995 in circumstances where there are delays in accessing home office support and the family has no alternative funds or housing available. Again, in those circumstances, the local authority will need to make sure that it carries out a GIRFIC assessment in relation to the child. It's important to note that when an asylum seeking family does not require accommodation from the local authority, for example, if they are able to receive accommodation and support under the 1999 Act, there is no restriction on the local authority providing social care services to a child, for example, to meet any needs that are arising from a child's disability. So just moving on to the next slide, I mentioned about a table that I think may be useful. So this is a lot on a slide, and I appreciate that. So that's why I'm not tending to really go through it, but it's useful for you to have a look at after today's webinar, just to look at, well, what is the actual status of the asylum claim? What is the home office support that can be provided? And what is the local authority position in terms of section 22 of the 1995 Act? So just moving on, conscious of time, so just moving on to unaccompanied children, as this is something that has come up quite a lot recently in relation to asylum seeking, unaccompanied asylum seeking children. So local authorities have duties to accommodate and support children in need in their area up to the age of 18, regardless of their immigration status. Local authorities also have a duty to provide leaving care and aftercare duties to formerly looked after children. So some key points to note. Local authorities need to have a process in place to identify a child's nationality and immigration status when their involvement begins or when a child's circumstances may change. A child's immigration status can change, so therefore it needs to be kept under continuous review and recorded within the child's care plan. A child with an outstanding immigration issue needs to be referred to specialist legal advice and support urgently, including a referral to the Scottish Guardianship Service where appropriate. All unaccompanied asylum-seeking children and non-EEA national trafficked children in Scotland are entitled to receive independent advocacy support of a guardian, and therefore they should be signposted to that as soon as practically possible. For children who do not have a form of immigration status that allow them to settle in the UK permanently, it will be essential to undertake triple pathway planning that accounts for how the different outcomes of their asylum and immigration claim may impact their ability to access healthcare, education and aftercare support from the local authority. And it should include appropriate planning for the possibility of their asylum claim being unsuccessful. When a young person is in an excluded group, for example, if they become appeal rights exhausted following their asylum claim, there should be the continued provision of aftercare support subject to human rights assessment and whether there are any legal or practical barriers preventing the young person from returning to their country of origin to avoid a situation of destitution in the UK. And as mentioned in the same with adults, that exclusion is set out within Schedule 3 of the Nationality, Immigration and Asylum Act 2002. And what that really means in practice is that in certain circumstances, support can be withdrawn from the local authority before the young person turns the age of 26. Planning to support a young person in these circumstances must involve establishing a durable pathway out of destitution. That could involve signposting to immigration advice to explore the possibility of pursuing a further claim to remain in the UK, support with employment when the young person has permission to work, or help with exploring assistance to a voluntary return to the country of origin when the young person is appeal rights exhausted. If a local authority withdraws aftercare support to a young person who is appeal rights exhausted at the age of 26 or earlier, the young person should be provided with information which can include signposting to Home Office asylum support, local charities, immigration advisors, and the Home Office Voluntary Returns Service. So what's the statutory framework? Section 25 of the Children's Scotland Act 1995 establishes the duty of local authorities to accommodate children in need in their area. Local authorities owe aftercare duties to children who were formerly accommodated by them under sections 29 and 30 of the 1995 Act and the Children and Young People Scotland Act of 2014. And these are further set out in the Support and Assistance of Young People Leaving Care Scotland Regulations 2003, as amended by the Support and Assistance of Young People Leaving Care Scotland Regulations 2015 and the associated guidance. Local authorities have a duty to prepare young people for leaving care or ceasing to be looked after, including the preparation of a pathway plan. These provide advice and assistance to young people who have ceased to be looked after on or after their 16th birthday, and provide aftercare support until the care leaver turns 19, and to assess any eligibility needs for aftercare support until they turn 26, or beyond in some cases. This may include accommodation where this cannot be provided in any other way. So, for example, through local authority housing department, or also by assisting the young person in securing social security benefits, including universal credit, to be able to obtain accommodation. In addition, under the continuing care provisions of the 2014 Act, young people who are aged 16 or older who are looked after in foster, kinship, or residential care placement are eligible to request to remain in their placement until the age of 21. And a local authority can only refuse such a request in limited circumstances and must prepare a welfare assessment explaining the reasons for such a decision. In terms of the eligibility for aftercare, so just moving on to the next slide. The duties of local authorities to formally look after children arising under the 1995 Act and the 2014 Act apply, even though the immigration status of a young person will affect entitlement to aftercare when they're 18 or older. Challenges can arise where a formally looked after child does not have leave to remain and therefore cannot access mainstream accommodation and benefits. And that can significantly increase the direct cost to local authorities of meeting those obligations. For some young people, when they turn 18, they may only be provided with aftercare under sections 29 and 30 of the 1995 Act, if it's necessary, as I mentioned, to prevent a breach of their human rights due to an exclusion in terms of Schedule 3. When a young person is in that excluded group, either when they turn 18 or older, as I mentioned, the local authority will need to undertake a human rights assessment in order to establish whether such support and assistance can be provided or whether the young person can return to their country of origin. So essentially, just before moving on to age assessments, essentially when it comes to the provision of support to asylum-seeking individuals, whether that be adults or young people, the local authority has a number of statutory duties that are placed upon it in terms of the relevant pieces of legislation. I appreciate there's quite a lot of pieces of legislation that come into play in such circumstances. However, the local authority should at all times be taking such decisions that are being made with a human rights approach at the forefront to ensure that any potential challenges that may come down the line in relation to the local authority's decision-making process is not subject to challenge on human rights grounds. So just making sure that it's always being looked at through the appropriate lens. So just moving on, we've short time left. I just want to briefly touch on age assessments because it does come up quite a bit. So there may be instances, and I've no doubt that a number of you that are on this webinar have probably supported social work services in an instance where the age of an asylum-seeking child is disputed. And what happens is that in such circumstances, this will have implications on whether that individual is treated as a child or is treated as an adult for immigration and local authority support purposes. And the impact of that can be quite significant. In practice, excuse me, in practice, it can be unclear whether an asylum seeker is an unaccompanied child or if they retain the age of 18. And so age assessments are part of the process that local authorities undertake to assess whether someone is an unaccompanied asylum-seeking child or not. And then to follow on from that, practically, what statutory duties are engaged? So you've got two types of age assessments. There's an age assessment that is conducted by a designated person under Part 4 of the Nationality and Borders Act 2022. These are binding age assessments carried out by officials appointed by the Home Office to carry out age assessments to determine the issue of age for, among others, local authorities in exercise of their statutory duties. And then there's non-statutory age assessments that are carried out for the purpose of enabling a local authority to determine whether or not it owes duties to an individual under the relevant pieces of legislation. So, for example, in terms of children, under the 1995 Act. Such age assessments are not underpinned by statute, but have instead been developed by the courts through case law. And the leading case on age assessments is R.B. against Merton, which gave rise to the concept of Merton compliant age assessments. So, what makes an age assessment Merton compliant? We just move to the next slide. Thank you. For an age assessment to be Merton compliant, it must consider the following principles. And these are set out in the slides together with the relevant paragraphs from the Merton case. So the age assessment in borderline cases is a very difficult matter, but it's not complex. It's a matter which may be determined informally, provided safeguards of minimum standards of inquiry and of fairness are adhered to, and that's in terms of paragraph 36 of the Merton case. Except in clear cases, the decision maker cannot determine age solely on the basis of the appearance of the applicant, that's paragraph 37. The decision maker must seek to elicit the general background of the applicant, including his family circumstances and history, his educational background, and his activities during the previous few years. Ethnic and cultural information may also be important, and if there is reason to doubt the applicant's statement as to his age, the decision maker will have to make an assessment of his credibility and will have to ask questions designed to test his credibility. A local authority must make its assessment on the material available to it and obtained by it, but there is not a concept of an onus of proof. Where an individual has previously stated an age and changed their position, this is relevant to the credibility, and a local authority should be considering the credibility of that individual, and that's set out in paragraph 38. And I certainly have been involved in cases where there has been a change from the individual in relation to their age. A local authority cannot simply adopt a decision made by the Home Office. By extension, this applies to decisions of other public bodies. And essentially, what's that saying in terms of paragraph 39 of Merton is that the local authority should undertake its own assessment rather than relying on the assessments of others. The assessor should have relevant qualifications to conduct the assessment, but this will not require the assessor to have the same experience as lawyers or as judges in terms of extracting evidence and information from an individual. That's out of paragraph 41 of the judgment. Local authority is under a duty to give reasons for its age assessment's conclusions. I'm sure that you will all be consistently used to the duty of local authorities to give reasons in all decisions. It is no different in age assessments. The court will not impose unrealistic or unnecessary burdens on those undertaking age assessments, but local authorities should have sufficient information available given the context to make an appropriate age assessment. And the person should be given an opportunity to comment on the provisional findings that they may be lying or on any other adverse matters, and that's paragraph 55. So it's just essentially the last paragraph is allowing an individual with a right of reply in the event you find that they are perhaps not credible when undertaking the age assessment. So what are the duties of local authorities when conducting age assessments? It has been held by the English courts that the local authorities should presume a person is a child if there is dubiety until proven otherwise to accord with its duties under Section 11 of the Children's Scotland Act 2004. That authority is quite likely to be followed in Scotland regarding local authority duties in accordance with Section 17 of the Children's Scotland Act 1995. A young person should be given proper opportunity during the interview process to respond to any points which may have an adverse impact, and the young person should have the opportunity to be accompanied by a responsible adult. This will require the individual to be given fair and proper opportunity at a stage where it's possible adverse decision can go against them, and also to deal with any important points in an adverse case against them. When applying the benefit of the doubt, a decision maker should conclude that an individual is under 18 where there is a doubt as to whether the individual is over 18 or not. The application of the benefit of the doubt test is nothing more than an acknowledgement that an age assessment cannot be concluded with 100% accuracy, and essentially that the local authority should err on the side of caution, providing a children's service in the interim pending a further age assessment. The benefit of the doubt should not be used where a specific date or age has to be determined. In the first year tribunal, immigration and asylum chamber, if they decide that someone is over the age of 18, then it remains the responsibility of the local authority to determine age for their own purposes. In doing so, the adverse findings from another context can be taken into account by the local authority. So essentially, if the first year tribunal were to find that someone is over the age of 18, whilst the local authority has to undertake its own assessment and satisfy itself on the basis of the information provided, that the person's age is what it is assessed to be, it can take into account the findings from the first year tribunal. And the reason why it's not binding is because the first year tribunal is not a court of general jurisdiction and it exercises specific functions. And this line of reasoning may be relevant to other forums, meaning local authorities will still have to satisfy themselves as to age dependent of findings in other forums. There is some guidance on age assessments, and there has been some case law on it, which I'll just touch on very briefly to close, because I'm really conscious of time. As I mentioned, there's quite a lot to get through, and it is a bit of a canter. So just in terms of age assessment guidance, Scottish Government first published its non-statutory guidance on age assessments in 2012. The guidance has been revised, and as I understand it, there's going to be some further revisions to age assessment guidance in the near future. It's been developed to assist local authorities and social workers by offering a framework that can be adapted to suit individual circumstances. The guidance covers the person's initial presentation, determines whether an age assessment is needed, and additional issues and vulnerabilities that may arise, preparing for age assessments, conducting age assessments, and what to do with developments after age assessments. And it also confirms that the decision as to whether it's necessary to undertake an age assessment is a professional judgment based on the individual's initial presentation and circumstances, personal appearance, and demeanour. In making this decision, social workers really should be alert to any unconscious bias and ensure that decision making is reasoned and robust. In the majority of cases, age assessments will apply to those persons who are considered borderline as to whether they're an adult or child and their age is in doubt. And age assessments should only be undertaken where it is absolutely necessary. The guidance also provides the following additional key factors. Where a young person has been assessed as being under 18, then their care and support should continue to be provided by a local authority's children's services. Where new information which could significantly change the outcome of an existing assessment comes to light, then a further assessment should be undertaken. And it may be inappropriate to subject a young person to a further full assessment, and consideration should be given as to the potential implications for the young person, and the decision-making rationale should be recorded and shared with the young person. The guidance is non-statutory, but is being prepared as a compliant age assessment carried out to professional standards that will serve the best interest of both the young person and assessing the local authority, not least because of the possibility of a challenge to a decision through judicial review. Now, just briefly on the law, on the case law, since 2017, it's been accepted that challenges to age assessments undertaken by Scottish local authorities should be taken in the form of judicial review proceedings. And that's further to the case of you against Glasgow City Council. That understanding was thrown into doubt in the 2024 case of Abdullah against Aberdeenshire Council, where the outer house of the Court of Session found that the petition was incompetent and the challenge to the age assessment should have been brought by an ordinary action for declarator of age rather than judicial review. The upshot from Lord Orrery's decision in Abdullah is that there are now two conflicting judgments from the outer house as to the correct route for future age assessment challenges. And that uncertainty was once again highlighted in the 2025 decision in the case of Amat against Aberdeenshire Council. In this case, the Lord Ordinary indicated that she was minded to agree with the reasoning of you against Glasgow City Council, and that her view was that the dispute between the pursuer and the local authority remains one properly within the supervisory jurisdiction of the court, and therefore judicial review is the appropriate remedy. So until there is authoritative guidance from the inner house, those seeking to challenge age assessments and also those seeking to resist them will face the prospect of treading a rather uncertain path. Whether decisions will continue to be challenged by way of judicial review may depend on whether Section 54 of the Nationality and Borders Act 2022 is brought into force. And this provides for appeals to the first tier tribunal against age assessments of persons subject to immigration control. So there's a little bit of watch this space. I'm very, very conscious of time and that we've ran over ever so slightly. So for the questions that have been posed, I will come back to you separately in relation to that so that I can let everybody get on with their day and not eat into anybody's lunchtime or anything they need to do before lunch. So we won't take questions just now, come back to them separately. Thank you very much for joining me this morning on what is a canter through of quite a complex topic with a number of different pieces of legislation and guidance to consider. Very happy to pick up with anybody offline after the webinar if we want to discuss matters further. And I'm not sure if we have any upcoming events that I need to bring to your attention. I don't think that we do. So all there remains for me to say this morning is thank you so much for joining me. Thank you for bearing with me as we ran over this morning. I do hope to see you all very soon.